get started today on Wednesday, March 9th. Thank you all for being here. First thing on the agenda, I believe meeting minutes have been sent out for February 3rd and February 7th. Has everybody had a chance to review those? And if so, do I have a motion?
I'll move.
Representative Smith's motions. Do I have a second? Oh, Representative Patton, thank you. On the minutes. We're on the minutes. We're on the minutes. Okay, we have a first by Representative Smith, second by Representative Patton to approve the minutes February 3rd and 7th. All in favor say aye. Aye. Opposed, no. Ayes have it. Thank you. We'll move on to final action on a handful of bills. And we're going to start with Senate Bill 366 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 366 would specify that the crime of burglary includes, without authority, entering into or remaining within any locked or secured portion of any dwelling, building, or other structure with the intent to commit another crime therein.
Any questions for Natalie? Seeing none, I believe Boog has an amendment. Representative Heiberger might have an amendment on this one. Oh, 408, my bad. 366 then, do we have any other amendments? If not, I do have an amendment because of the utter importance of this piece of legislation. I think that once it passes, it needs to become enacted on publication in the registry. So I'm going to offer that pretty straightforward conceptual amendment. Yes, Representative Osmond. We will do that, so I do amendments first, and then we'll have a motion on the bill as a whole. So I make the motion to change it to publication on the registry. Do I have a second? Representative Smith, thank you. Any conversation or discussion on that? Representative Carmichael.
Thank you, Mr. Chair. And just because we're, so to speak, on the record here, I think you're not meaning to say registry, you're meaning to say upon publication in the state register.
Register, correct.
Now, I oppose the idea, okay? Criminal laws, like all laws in Kansas, are effective upon publication in the statute book, and that typically takes place July 1. And we all know and understand that that's when the laws change. If there was a clear emergency here, then perhaps we do need to not follow the usual practice. But this bill, in my judgment, is no more or no less important than than 3 out of the 4 remaining bills that we have on our agenda. And so I don't believe that this particular bill needs to have that emergency status. Once we open that door, then everyone who darkens this committee room's door is going to say, my bill is very important too, and it should be effective upon publication in the register. And I can just tell you from the standpoint of a lawyer who does a little bit of practice, it creates problems when you have an effective date that is other than what's usually expected. It's an invitation for people to make mistakes and confusion. And I just, with respect, Mr. Chair, I just don't feel that this particular bill is of that great an importance. Thank you for hearing my words.
No problem. From my perspective, and I completely understand your perspective, my goal is to amend this bill so that we can get it into conference, so that we can work on a few other things. And so if that is an utmost concern to you and to others, we can certainly address that in the conference committee report as well.
I do understand that noble purpose, and I trust that our chair, if and when, and our ranking member and our vice chair, when this matter goes to conference, if necessary, that you at least keep my words in mind. Thank you.
Duly noted. Thank you, Representative. Representative French.
Thank you, Mr. Chair. I don't see an amendment. What am I looking at?
So because it is just a very simple amendment, we just did a conceptual amendment on this. I didn't have Natalie draft up changing it.
And so it's
just change the wording from, go ahead, Natalie, if you want to explain it.
Mr. Chairman, so this would be on page 2 in line 30. We would just strike the word statute book and insert Kansas Register.
Okay, got it.
That's all, just trying to save our revisers a little bit of work.
Got it.
Because this is pretty common.
Thank you.
Yeah, sure, no problem. Any other? Representative Resman.
Thank you, Mr. Chair. Just something to think about. Normally what happens, the department I retired from, towards the end of June, we have meetings that go over all the new laws and all the changes that take effect on July 1st. So you may want to consider that this bill will encompass all the other bills that are passed at one
Sure.
time.
Duly noted, thank you. Any other discussion? All right, committee, all in favor of the amendment, say aye. Aye. All opposed, no. Ayes have it. Thank you very much. We're back on the bill. Are there any other amendments on Senate Bill 366? If not, do I have a motion as it relates to Senate Bill 366? Representative Resman. So moved as amendment. Do I have a second? Representative Smith? All right. Any discussion, committee? All right. Seeing no discussion, you may close, Representative Resman. Thank you. All right, committee, all in favor of passing House Bill 366 favorably as amended, say aye. Aye. Opposed, no. Ayes have it. Thank you very much. Representative Heiberger, Representative Carmichael, those are our recorded ayes. All right, moving on to SB 408. Natalie, give us an overview on that one.
Thank you, Mr. Chairman. Senate Bill 408 would increase the criminal penalties for multiple thefts of mail and make those a felony, whereas right now they'd be a misdemeanor if the value of the property being stolen is less than $1,500.
Very good. Any questions for Natalie? All right, amendments. Representative Heiberger.
Mr. Chair, now that we're doing conceptual amendments,
Conceptual amendments, that's right.
I have one for, if you're looking at the bill, it would be on page 2, lines 19 and 20. I would propose to strike the language that says that excludes from the definition of mail or a sealed article or thing addressed to a person. This would just exclude those items that aren't delivered by a regular delivery service. For instance, I don't think it would be a horrible crime if you left sealed Valentines with their neighbors' names on them on all their porches and somebody came by and stole 3 of them. I think that would be a horrible offense, but probably not a felony. I can't think of any other any instances where this would apply, except there's situations like that. So, and if anybody needs a copy of the bill to look at, I've got one right here.
Care to move your amendment?
I move my amendment.
Do we have a second? Representative Smith. Discussion committee.
I would note that Eric Stafford assures me that his group he represents is okay with it.
Okay, very good. Representative Carmichael.
I apologize, Mr. Chair. I didn't wear my hearing aids today. I wasn't clear if the amendment, does it strike the deliveries by FedEx and the like, or is it just the sealed left on somebody's porch?
It's just the sealed article or thing addressed to a person and not delivered by a delivery service.
Okay, thank you.
Absolutely. Any other discussion? You may close, Representative Heiberger.
I close and move my amendment.
Very good. All in favor of the Heiberger amendment, say aye. Aye. Opposed, no. Ayes have it. We will consider that passed. Back on to the bill. Any additional amendments? Any additional discussion? Representative Carmichael.
This idea is, Mr. Chair, this idea has been around for a few years. I understand that theft of packages off of people's porches is a serious crime. It's a serious problem. It's dealt with in the present statutes. I don't think that escalating 3 instances of theft to a felony is going to do anything to deter this crime. I think instead it just has the potential, it has the potential to over-criminalize, at least in my judgment, the conduct involved. We determine the level, what is or is not felony theft in this state based upon the value of the property. I mean, traditionally, that's the way we've always made those determinations. And I understand the shoplifting statute is an example of something similar, but I don't believe that it's really necessary for us to turn every type of bad conduct into a felony. And I just seem to see us doing that more and more. So I'm going to be a no vote on this. I'm going to sleep well at night, no matter what the outcome. But I just think we ought to move slowly about this increasing tendency to escalate what were once misdemeanors into felonies, because I don't think it will create the results that the proponents seek. Thank you.
Representative Smith.
Thank you, Mr. Chair. I think the point of the previous representative is well taken. Unfortunately, I disagree. I think proportionality is important here. We talk about not just shoplifting, but also financial card crimes or crimes that involve a behavior that's consistent with a criminal enterprise. And I see this as a growing problem in our community, that if we don't treat it differently than somebody who just takes an opportunity, but rather uses it as a means of financial subsistence, I think that we don't deter it. I think it continues to be a problem. So in some way, and I agree with you, this does not stop it. It would be nice if we could come up with a law that completely stops any crime, but that's not the way it works, is it? So, well, so I'm protecting my job a bit, but I will be supporting this bill.
Thank you. And I realized before we continue our discussion, I failed to ask if we have a motion as it concerns this bill. So probably ought to see if we even have a motion to pass it out favorably at this point. So moved by Representative Smith. Do I have a second? Representative Patton. All right, carrying on with discussion. Representative Howell.
Thank you, Chair. As I recall, unfortunately, I don't remember who off the top of my head, but as I recall, while we listened to testimony, one of the conferees actually addressed the issue about how doing similar consequences, I think it was for shoplifting, has been an effective tool. So they're taking, because it was effective over in that incident, they're transferring it over here in hopes that it would be effective here. So that tends to give me hope that this will work and help move the needle on these kinds of crimes.
Thank you. Additional discussion. Representative Heiberger.
Thank you, Mr. Chair. I certainly agree with everything that the representative from Wichita said, but I also recalled testimony that Representative Howell pointed out. In this, and as Representative Smith said, this is a growing problem, so I'm going to reluctantly support this bill this time.
All right, thank you. Additional questions or discussion? Seeing none, Representative Smith, you may close.
I close.
All right, thank you very much. So all in favor of passing SB 408 favorably as amended, say aye.
Aye.
Opposed, no? No. Ayes have it. Recorded votes, Heiberger as an aye, Carmichael as a no. All right, we're going to skip over 368, and I'll tell you why here in just a second, and jump into 385.
Mr. Chairman, Senate Bill 385 would require registration as a sex offender for certain violations of the crime of breach of privacy, specifically subsections A6, A7, and A8.
All right, thank you. Any questions for Natalie? Okay, seeing none, I will go ahead and jump. What I would like to do, if you could send out this amendment. This amendment is actually We will in just 1 second. I generally do the amendments first, and then we jump into a motion. The amendment that will be sent out, basically all it's doing, these are both sex offender registry bills, increasing crimes. I propose to take the contents of SB 368 and add them into SB 385. So we're just moving one bill instead of two. I move that a motion. Representative Patton is the second. Discussion on the amendment. Representative Heiberger.
Thank you, Mr. Chair. I would much separately vote on these bills separately, so I'm going to oppose the motion.
Understand. Additional discussion. Okay, seeing none, I close my amendment. All in favor of the Owens amendment say aye. Opposed, no? No. All right, the ayes appear to have it. Ayes do have it. Motion passes. So now we have amended SB 385 that has the contents of 368 in it. Do I have a motion as it relates to SB 385? Representative Smith.
I move that we pass SB 385 as amended favorably.
Do I have a second? Representative Howerton. Discussion. Representative Heiberger.
Well, I guess as I think we all know, Kansas has the most overextended offender registry in the country, probably. And so in general, I've opposed any new attempts to do that. I mean, I was willing, on 385, it's the privacy bill, I was, because of the very moving testimony and because, well, one thing we also hear in doing this is that people in the sex offender registry, the recidivism rate is actually lower than the general population rate. There's testimony indicating that at least some of the individuals involved in this crime were multiple repeat offenders. And so that really part of that concern. And they did seem like crimes that are comparable to crimes that are already on the registry. So I was ready to bite the bullet on that one. But on the internet, distribution of pornography, I don't recall the exact terms. I mean, I don't see how placing somebody who commits an internet crime is going to be, how that's going to provide any safety to someone if they know that person's in their neighborhood. Even though the number of, as Representative Smith pointed out, the number of convictions under the act is very small, 2 a couple of years ago, none last year. I was ready to oppose that as a standing measure, and I'm still not sure how I'm going to vote on the package.
All right. Additional discussion. Representative Howerton.
Thank you, Mr. Chair. Just remind me, it was my understanding on, sorry, I can't read, 368, that the law already says that someone convicted of pornography is on the sex offender list. And then this is like a more intense, aggravated. Internet trading was not. And so it wasn't the same. So we have less offensive on the sex offender race, or less of a crime.
How about we ask Natalie, see if she can
Somebody clarified that for me.
help us
Thank
decipher
you.
that. Because you're right, as I understand it for the most part, but
Okay.
she's much more eloquent.
Mr. Chairman, Representative Howerton, so no form of internet trading and child pornography is currently on the sex offender registry, whether it's the regular version or the aggravated version. I think perhaps what you might be thinking about is that sexual exploitation of a child. So if you're in possession of child pornography, that is on the sex offender registry. So that's a different crime. It's still related to the possession of child pornography, but currently no version of this crime is on the offender registry.
Representative Smith?
I think this absolutely fits in with what we heard yesterday in the moving testimony yesterday. The fact is, yesterday, I think we heard from victims firsthand, and that was very moving when you hear that. In this crime, internet trading and child pornography, you don't often get to hear from the victims. One, they may or may not know that they are being victimized at the moment that they're being subjected to this. But I find this to be one of the most violent crimes. When we talk about violence, this is traumatic, it's lifelong, and by trading on the internet, you are proliferating this commercialization of this crime. It occurs, and this is, to me, just a small measure of what we can do to keep track of those individuals who can't seem to find the switch to turn that off. So recidivism with child sex crimes is fairly high with those who perpetrate that. Oftentimes you find when one finally gets identified, others come forward, right? This feeds their need, this internet accessibility. And this is just one tool that I think we can use to combat it, and so I'll be voting for it.
Thank you, Representative. Representative Heiberger.
Well, I mean, you could not tell that by the testimony of anybody who testified last week, including the prosecutor, that the placement on the registry is a civil process designed to protect the public, not a punishment. And so all the testimony I heard on both these bills was that they wanted to increase the punishment for the people who did this. And I mean, that's what I'm hearing from you too. And so I think that's not what the offender registry is for. And so that's really the main source of my concern.
I think, yeah, and I'm going to add a comment in here myself. I'll raise my own hand and call on myself. You know, I'm always very critical of our offender registries, what makes sense, what doesn't, what's proportional, what term length makes sense. Representative made a comment a little bit earlier that he doesn't believe that this will protect anyone if they know that this person's in their neighborhood. I think to myself, if I have children, I want to know somebody's in my neighborhood that trades in child pornography, especially if they could potentially be taking pictures and sending them online. And so we can certainly debate length and so many other pieces of the offender registry, but this is one that I think specifically when we're dealing with children, we did hear from children that were violated, maybe not on this bill, but on the other one. And those lasting effects, when that comes to fruition, certainly warrants, in my opinion, the passage of this bill. So, Representative Resman.
Thank you, Mr. Chairman. I just want to remind everyone that victims of child pornography are victims for life. Once it goes out on the internet, it's there forever. And I can tell you, we recovered many computers that have the same images on them. So they're victims for life, and that's really sad.
Representative Howell.
Thank you, Chair. And I apologize, Representative Heiberger. I realize I don't know what town you're from, so I can't say it that way. But I do understand your concerns, and I will be very honest and just say, since coming to serve on this committee, I have been shocked about some of the intrusiveness and the length about our different registration lists and offender lists, okay? I mean, I was very shocked about the drug offender list, for example, okay? I mean, this is just outside the scope of my world of experience, okay? And so, I mean, I share the concerns that I know you have. I would say, even if maybe the people that testified the other day did not address this issue, I would have to agree with some of the other comments in the sense that I think as a parent, you know, or, I mean, to me, it's more important to have protections for parents. And, you know, if I was, you know, I'm blessed because I'm happily married, but if my husband died and I had little kids, I would be checking every single person I dated or was willing to come into my home with my children, and I would be looking at this list. And so I think it is an important tool to protect the public. And in this case, I think this is a reasonable action, consequence, and there are other things that we can do to hopefully improve the registration lists and things in ways where it's not good. But I think in this case, this is appropriate.
Thank you. Additional discussion committee. Representative Howerton.
Thank you. Thank you for clarifying that earlier. So I'm still kind of reeling from the testimony yesterday. I called my daughters a little bit after that and told them that this weekend we are going to be watching committee testimony because I want them to hear it firsthand, not from their mom, but out of the mouth of their peers, and to be aware. And I hope that somehow those girls are able to get that testimony out for everyone to hear. So I will be supporting this. It'll be my new passion. I'm probably telling everybody. We need to know that.
I understand. I consider myself incredibly blessed to be able to be here, to work on these topics. I know they have certainly forever changed my family as I take stories like that home and share with my children in various facets of what we do here. So I do understand. Representative Smith.
I struggle with the idea of adding this, but to be clear, and I've shared with the chair before that I also have feelings about the registry and where it oversteps. I believe there are times when people are put on the registry for lengthy periods of time that's not appropriate, it's not helping, nobody's gaining anything from it. In this case, I want to be clear that I don't just feel it's punitive, although I will agree and I won't defend that in some ways it certainly is punitive to be put on a registry. But I think that it's ultimately important, and the chair expressed more clearly that I think, in my opinion, that it does give us a tool for just that, to keep track of those folks that may make a victim of folks in your own neighborhood, or as the other representative spoke, and individuals you're going to invite into your home for long periods of time. So anyway, I just want to make that clear.
Thank you. Additional discussion committee. All right, Representative Smith, I believe you may close.
I close.
All right, all in favor of passing SB 385 as amended favorably, say aye.
Aye.
All opposed, no. The ayes have it. Ayes recorded are Heiberger and Carmichael and French. All right, finally, last bill, House Bill 2705. Let's move on to House Bill 2705 and give us an overview on that one, Natalie.
Thank you, Mr. Chairman. House Bill 2705 would remove the rebuttable presumption of an intent to distribute controlled substances and replace that with a permissive inference.
Very good, thank you. Questions for Natalie? Definitions by Natalie. Okay, there you go. We can roll with that. There you go. I did want to mention on this bill, we did end up getting testimony from the Attorney General's office later. It was mentioned by Representative Carmichael that we didn't hear from them or law enforcement. And so the AG did send out a kind of a one-page in support of this as well. So make sure you guys commit that to memory. Representative Howerton.
I was just going to share, I Googled the definitions because I was still unclear, and there's a great cartoon of a little girl with a soccer ball with a broken window, and it says, I can't even read this, may I present rebuttable, I can't read it, presumption by stating that I'm too young to be held accountable. So, anyway.
There you go.
Whoever carried the bill might want that cartoon.
I know who might be a good person to carry that bill. All right. Sure, yeah, no problem. Are there any amendments as it relates to this bill, committee? Do I have a motion as it relates to this bill, committee? Representative Heiberger.
I move that the committee recommend House Bill 2705 favorably for passage.
So moved by Representative Heiberger. Do I have a second? Representative Osman. All right, discussion. Representative Carmichael.
Thank you for your patience with me, Mr. Chair. You know, some days I feel like I'm the lone voice in the wilderness of opposition, but I think it is important in committees that we do try to hear both sides, even if I speak against a bill and then proceed to vote for it, as I would have the last bill had I spoken. But I'm concerned about this. This rebuttable presumption has been in the law for many years. There is the case of State v. Holder, which is the case that brought this to to Mr., I believe it's Stanton, the prosecutor from Hutchinson's attention. The Holder case is kind of convoluted in a sense because there's a whole bunch of tangential issues that really keep it from being a real clear decision. But there's a suggestion that the courts are at some point going to say the rebuttable presumption may well constitute a violation of a defendant's rights because the state has the burden to prove each and every element beyond a reasonable doubt. And a rebuttable presumption by its terms transfers that burden, if you will, to the defendant to respond. What I think, and I wish that the distinguished former prosecutor and fine lawyer from Garden City was here today, because I would really like to have had his input and his perspective on this bill. I know he had thoughts, and I don't think either he or I were entirely clear when we left here as to whether Holder said what the prosecutor, the proponent says it said, and whether or not we ought to do this. We had minimal public input on this bill. And I'm not blaming folks because that there was short notice of the hearing. That's the nature of our process here. But we didn't hear from the usual suspects, if you will. Kansas law enforcement. A detailed explanation from the Attorney General's office of the law and the applicable precedents. We didn't hear in a formal way at all from the Kansas County and District Attorneys Association. I believe it's Mr. Stanton, I think is the prosecutor's name. He said he'd talked to them and they were in favor of his bill. We didn't hear from the criminal defense bar. And I will tell you that after the hearing, I did reach out to folks, the usual suspects, if you will, and they sent me a fairly long email expressing their concerns, but as we would say in the law, that's not in evidence here, and I'm not going to try to make their argument for them. But I think we ought to be real careful about, one, presuming what a court may do in the future, and number two, making this important decision without really having a full deck of cards, all the major players here expressing their thoughts, whether this is a good idea or a bad idea. A permissive inference is not something that at least I learned anything about in law school. I've now read the Holder decision. I think I understand probably what they're trying to say here. But there are unintended consequences sometimes when we move too rapidly and without appropriate information in our hand. And so, you know, if you make your decision based solely upon the evidence that we've seen and heard in this committee, then I think you're going to vote in favor of this bill. But I think there's, as Paul Harvey used to say, the rest of the story, and we haven't heard the rest of the story. And we're making a pretty big move in the criminal law here, in my judgment, without a full appreciation of the issues, a chance to talk to the Attorney General's representatives and have a scholarly discussion with them. And so I'm going to be a no on this. And under different circumstances, a different day, I think I could probably be a yes. But sometimes you just get that feeling that there's something going on here, and unless and until I'm confident that this is the right decision to make, I'm going to have to vote no. Thank you.
Representative French.
Thank you, Mr. Chair. And tying into what the representative just said, I had the same problem last year with bills like this coming to this committee. To me, I don't know why this kind of a bill would come to corrections and juvenile justice when it obviously belongs in the judiciary. I know you don't get a chance to pick which bills come here and which don't, but I hate doing the judiciary's business for them. And to me, this is where it ought to be, when you have knowledgeable people that can understand this kind of stuff, because Most of us here don't. We just don't understand it. We shouldn't be working it. That's my opinion. Thank you.
Chairman Patton and I joke about that regularly. There's kind of no rhyme or reason why they end up here or there or sometimes anywhere. Representative Smith.
Thank you, Mr. Chairman. I was actually kind of looking forward to what the representative from Wichita had to say, and I was also looking forward to what the representative from Garden City might have to offer on that. Only because later, as I was thinking about that, the second sentence that's added on line 22 on page 3, where the change is made, and there are facts to support such inference, seems either redundant or stacking. One of the two. And what I mean by that is, and I don't purport to be an attorney or some scholar of law, but the fact is, occasionally you get away with it though, and I don't. But anyway, to say that it's a permissive inference, I think is presuming that there are facts to support such an inference, and that would be by the weights, but this would seem to say you're going to need more than the weights. And I'm not sure, I think that changes that changes it quite a bit more than just moving it or shifting it back to the state to prove. I think it changes what they have to prove along with the weights. So I guess if you're a proponent of that idea, this would be acceptable. I think in our description of what 450 grams of marijuana means, it means more than 400 joints, is kind of, to me, well, it depends on how big they are, I'm sure, yeah. Usually 1 gram to 2 grams is what the average joint is, so 450 grams, you do the math. That's a part that I have a problem with, so I would say the jury's still out with me. I'll pass it out and go ahead and get it out of committee, but I may have to change my mind later.
Representative Heiberger.
Thank you, Mr. Chair, and it kind of bothers me to disagree with my more experienced colleague from Wichita twice in the same day, but I think I'm going to this time. And to Representative Smith's point, yes, I think that the sentence on line 22, and there are facts to support such inference, is a critical part of the amendment. It's not stacking. It's the none of it. And if I recall right, that's our witness testified that that's their practice now. They don't just, under current law, all you have to do is prove 450 grams, and then you've proved your case unless the defendant comes up with some evidence to prove otherwise. And under this, you've got the 450 grams, and that says that then with a few some slight additional fact to support the evidence that there's intent to distribute, then you can make the finding of guilt. And so I think I have not read the Holder decision, but I would support this change. The way I understand the meaning of rebuttable presumption and permissive inference, I would support it regardless of whether that case was there or not. So.
Additional discussion. Back to Representative Carmichael.
Thank you. First, let me address the remarks of my liberal friend from Lawrence. Liberal lawyer
from Lawrence.
Liberal lawyer from Lawrence. And one time we referred to a gubernatorial candidate as a lying liberal lawyer from Lawrence, but never mind. It's one of those dark places. We all know that. But I trust his reference to my experience is experience in the law, not superior experience with marijuana. I disclaim any knowledge of that. But to respond, though, seriously to Representative Smith, I have looked at the language that you reflect. I don't find that additional clause to be of concern. I think what it is accurately stating the general principle of law that before an instruction can be given, there have to be facts to support the instruction. And in this instance, it's saying you don't give an inference instruction unless there are facts to support an inference. So I don't find that clause objectionable. If my concern is about the use of the phrase permissive inference and whether that's the right way to go about this. So if that sets your mind at all at ease, I guess that's the point that I really wanted to make, and I appreciate my friend, the liberal lawyer from Lawrence, acknowledging my 11432 bar number. Thank you.
I was referring to your legal experience, sir.
Did you have any follow-up, Representative Smith?
I did. Thank you, Mr. Chair. I just, here's where I was going with that idea is if it said instead, in any prosecution under this section, there shall be a probable cause of an intent to distribute, and then followed by, and there shall be facts to support such probable cause. Well, that's basically defining probable cause again. So then it infers that there will have to be additional to the probable cause. I realize that that's a different standard. That's a standard of evidence, and I get that. But it almost, it's saying a permissive inference and then saying, which means there should be facts to support it. I don't know. I'll try to do some research, and if you have something to offer to me to help me in that understanding outside the committee, I'd appreciate it.
All right. Yep. Representative Heiberger.
Yeah, I see this as a little bit different because I think what creates the grounds for the permissive inference is the evidence of possession of a certain amount of controlled substance. That by itself creates a permissive inference, but that creates the availability of the permissive inference, and then to achieve that, you have to file some other factual evidence to support it, like joints or scales or whatever else there was. Is that, that's the way I understand it, I guess.
Anything else, committee? Good discussion. All right, Representative Heiberger, you may close.
Thank you, Mr. Chair. I move that the committee recommend House Bill 2705 favorably for passage.
Very good. All in favor of House Bill 2705 say aye. Aye. All opposed say no. No. Okay. Sounded like the ayes have it. The ayes do have it. We'll go with that. Representative Heiberger wants to be an aye. Representative Carmichael wants to be a no, and Representative French wants to be somewhere in the middle. So, well, that's right. It definitely is one of those topics that can challenge our thinking sometimes, which I joke that almost after 4 years in judiciary, I should get an honorary law degree for as much as I have had the ability to learn. So, all right, committee. Well, that finishes up what we have on the agenda for today. I want to take a minute because quite likely this is going to be our last meeting here. We don't have anything else waiting, short of some surprise coming from the Senate or something like that I'll probably pitch to judiciary. We will likely be finished here. And so I wanted to take a moment, everybody, and just really thank our staff for the work that they've done this year. Colette is a new committee assistant, as well as Lindsay, who's new to the committee as well, Meredith and Natalie, who continue to do remarkable work for us, and Rachel, who kept us online the entire time. So thank you guys all very much for the work you've done. With that, we'll likely have a meeting at the rail just for minutes at some point next week just to conclude things. But other than that, I can say that we're adjourned. Thank you.